All right. I'm so glad that so many people are interested in the topic of kind of utility basics and how to protect low-income customers from the loss of critical utility service. Just real briefly, the Utility Law Project provides advice, representation, education to both advocates and individuals facing the loss of termination service. At the end, we'll cover a couple of resources, but I just want to real briefly mention as well that MidPenn Legal Services and Community Legal Services also provide direct representation of low-income individuals who may be facing the loss of service. We all do some advocacy on these issues as well, so hopefully will be a resource to you moving forward if you have cases that you need assistance on or as a place to refer. What we're going to talk about today are really the basics. So I'll start by spending just a moment explaining the difference between regulated and unregulated utilities. We'll talk a little bit about utility affordability programs that may be available. We'll talk about, I'll turn it over to Joline then, who will talk about how to prevent termination, kind of some of the main strategies, as well as preventing termination as well as connecting or reconnecting to service. We'll then turn it over to Matt, who, as you heard, handles a lot of landlord-tenant cases, who will talk about tenant protections, and he'll address kind of what the PUC dispute process is, and then we'll close it up with some resources and referrals. But if you have questions as we go through and want to ask them, type them into your chat box, or hold them to the end. Either way, we'll try and get all of your questions answered. So I want to start us out by talking about what are we talking about today. And by and large, with the exception of a few tenant protections, mostly we'll be talking about regulated utilities today. So that would be your large electric and natural gas companies, as well as the private water companies. So it includes PECO, PPL, Duquesne Light, the First Energy companies, so Penelec or West Penn Power. There are others as well, UGI Gas. Those are what we consider, or what are considered, regulated utilities. They're subject to the jurisdiction of the Public Utility Commission, which essentially acts as a court for the utilities and will handle disputes that arise between consumers. Complaints are, of course, filed with the PUC, and they must follow rules and regulations set by the PUC and by the legislature. They also have to offer, they're mandated to offer utility assistance programs, and we'll talk a little bit about what those are. Many of you probably already know some of them. Hopefully we'll give you some insight into some others. There's also this whole other world of unregulated utilities, and we often refer to that as the wild, wild west of utilities, because they don't have to comply with the same rules and regulations as regulated utilities. This would include most of your municipal water utilities, sewer utilities, electric co-ops that may be operating, in a very small contained area or owned by a municipality. Consumer complaints in those kinds of cases would be filed with the Court of Common Pleas. And they're subject to several laws, though they're pretty broad laws. They don't include things like payment arrangement standards. They do include some broad notification requirements for the loss of service, but again, they're pretty hard to enforce. So, we could spend a whole day on unregulated utilities, but today we're going to focus just on what you can do for folks that are in a regulated utility. Moving on, I'm going to shift gears to talk about utility affordability just a bit. Now, I will say we live in a commonwealth with 67 counties, and as you know, they all operate very differently. Utilities are much the same way. So while utilities are required to offer what's known as a customer assistance program, they're going to be very different. So I'm going to cover what the broad standards are that kind of go across all of these regulated utilities. But each each program has slightly different rules and operates slightly differently. So if you get a case and you're wondering about specific rules for a utilities customer assistance program, let us know. Now, you should know CAP, or Customer Assistance Program, is also known by many different terms throughout the state. So for NFG gas up in Erie, it's called LIRA. It might be called PCAP in the First Energy companies, CRP if you're with PGW. There's many different names, OnTrack for PPL. But all of these are basically the same general rules. A customer assistance program, first, it provides three main benefits. The first is the discounted bill. So once you get enrolled in CAP, and they're calculated, the discount is calculated differently depending on what utility you have, but generally it is targeted to achieve a level of affordability that the Commission has deemed affordable. Now, sometimes it doesn't work to reach affordability, and even by Commission standards, affordability might be as much as 17% of somebody's income. Sometimes it even exceeds those Commission standards. So we work every day to try and drive those costs down and try and drive the level of affordability to something more realistic as a portion of someone's income. But still, it usually helps get someone towards affordability, even if it's not true affordability. The second benefit is that any debt that you had when you enter the program is frozen. And the third benefit is, as you pay your discounted bill every month, a portion of your arrears are forgiven. So if you enter with $1,000 over time, that debt, it won't accrue any late fees, but you can work it off by paying your discounted bill. Now, eligibility, generally it's at 150% of the poverty guidelines. You must be also payment troubled. Now, we think all low-income people are likely payment troubled because they're surviving below the poverty guidelines and don't have enough to make ends meet, but some utilities require that you have entered a payment arrangement or perhaps broken a payment arrangement. They all have slightly different ways of defining what it means to be payment troubled. But generally, if you're reaching out as an advocate to try and help someone enroll, and you're saying this person is having trouble paying their bill, they can usually enroll in the program. They also need to verify their income, which can be a problem sometimes if folks don't have verification, but generally a letter from somebody who's providing them with some form of income is sufficient. Income standards, of course, change. I'm going to move on to LIHEAP. Now, I hope you all have heard of LIHEAP. It is a grant assistance program generally. It also can provide crisis interface, which is they'll repair or replace an inoperable heating system. But the main components of LIHEAP are a cash grant and a crisis grant. It runs through the Department of Human Services and is available generally November through April, though that can change year to year as far as when the program opens and when it closes. It can be used for either gas, electric, or deliverable fuel. This might be oil, it might be wood, coal, and any type of deliverable fuel. We've also had some success getting water grants or LIHEAP grants to be used for water if water is required to run your heating system. So if your client has steam heat radiators, for instance, they might be able to get a LIHEAP grant to help pay for their water bill. The two components, cash grant, you can get a cash grant every year. So I always have clients, as soon as November comes, apply for LIHEAP and get that grant applied to help reduce your bills going into the winter. The second component is a crisis grant. Now, there's a couple other requirements with this. You must have an imminent home heating emergency, meaning you're terminated or you're about to get terminated. The grant must resolve the crisis. Typically, the grant maximum for a crisis grant is $500. So if you owe more than $500, you might have to help the client, or if the client owes more than $500, you're going to have to help them piece together. Maybe it's some of their own money, plus a $500 LIHEAP crisis grant, plus maybe a charitable organizations grant, or as we'll cover in a moment, a hardship fund grant. But generally, if you can piece together enough funds to make it so that the utility will agree to stop termination, then you're in the clear, and they'll accept that LIHEAP grant. Always recommend going after it. The utility will generally accept less than what they're asking in order to resolve the crisis. So if you owe $1,000 and the utility is willing to accept $500 and stop termination, then the grant will go through. Of course, apply on Compass. It's not open right now, so unfortunately it's not an available resource, but come November it becomes very handy. Keep us moving here. The next program I just want to touch on briefly are hardship fund programs. These are run by each of the large regulated utilities. They provide a cash grant, which is typically about $500. And like the LIHEAP grant, like the LIHEAP crisis grant, it must resolve whatever the crisis is. So again, if they owe $1,000 and the utility will accept that $500 hardship fund grant to stop termination, they may be able to get that assistance. Eligibility for the hardship fund programs are typically at 200% of the federal poverty guidelines. So those who are between 150 and 200, this is where they can find some assistance. Sometimes there's a recent payment requirement, meaning they must have made a certain amount of payments within the last several months in order to qualify. But you can get an exception for that. So say somebody has been out of work for the last couple of months and has been really dealing with some other crises, so they're not showing that they had payments over the last couple of months. You might be able to get an exception to that rule, but you have to ask. They're not just going to offer that exception off the bat. You also have to demonstrate some kind of temporary hardship. So I have yet to run into a case where someone's behind in their bill and they were denied because they didn't have a sufficient hardship. If they're behind and they're struggling, generally they're going to qualify for a grant. I will note that if folks are enrolled in CAP, some of the utilities prohibit a currently enrolled CAP customer from also receiving a hardship fund grant to pay for their CAP bill. So that's something to watch out for. But again, with a request, especially a request from an advocate working with a family, generally you can get a utility to make an exception in a difficult case. I will note that hardship funds are funded through voluntary contributions. So you'll note generally if you have an electric bill, you've probably been asked to contribute to the hardship fund before. Those funds are then matched with utility shareholder dollars, and that's what funds these programs. So some of you on this webinar are probably well aware that during certain times of year, there just aren't funds available through this program. I will note, though, that many of the utilities will release funds at certain points of the year or certain times of the month. So if an organization that's administering a hardship fund says, oh, we're out of money, sometimes it behooves your client to call back the next week and see whether or not there's more funding available. That was a very brief overview of the payment assistance utility affordability programs. And now I'm going to turn it over to Joline Price to get us started talking about how to prevent a termination.
Thanks, Liz. Hi, everyone. My name is Joline. I'm a staff attorney at Community Legal Services. Happy to be here talking to you about utility issues. So I'm going to talk about preventing termination just a little bit. I think a lot of times that you interact with folks who are dealing with utility issues, they may come to you with a termination notice. Utilities are authorized to terminate service to properties for non-payment of delinquent accounts. Also for other reasons, which can include failure to permit access to equipment, if the utility needs to make repairs, failure to comply with a payment agreement. Those are some of the reasons that utilities can terminate service. But what we're going to talk about is what your clients can do before that termination happens. So first important point is that terminations can only happen Monday through Thursday. Utilities are not allowed to terminate on Fridays, nor are they allowed to terminate on weekends. So if someone gets to Friday, they have until through the following Monday before the utility can terminate them. In addition, victims of domestic violence who have a PFA or other court order indicating domestic violence cannot be terminated for non-payment of residential service that was in someone else's name. That's an exception to the general rule that some individuals can be, that you generally can be held liable for arrears that are accrued in other people's names if you were living in the property or on the lease at the time. So utilities do have to follow specific notice requirements of before they terminate. They have to provide a written notice of termination, and it has to be provided at least 10 days before termination. Once they provide that notice is good for 60 days. So even if a client gets past the date on the notice, it said they got a notice on June 1st, it said they're going to get terminated on June 10th, the utility actually can act to terminate under that notice through the following 60 days. So that would take you to approximately the end of August. The utility does have a requirement to attempt to contact the customer either in person, by phone, or electronically before 3 days prior to actually terminating. That can include outbound calls to the phone number they have on file and does not require that that your client or the utility ratepayer actually answer the phone. Customers do have to affirmatively consent to receive notice like this through email or text. This is something that they often will give as a payment for service, and they may have forgotten that they did that. In addition, if the utility knows that a customer has a protection from abuse order or other court order indicating domestic violence, they do have to attempt personal contact immediately preceding termination. And if that personal contact is not successful, they actually have to post a notice at the property and delay termination for 48 hours. So that's if you are working with victims of domestic violence, it's rather important that the utility have note of that in their system so that they are entitled to that extra notice of termination. So you look at it. This client gets a termination notice, obviously wants to keep their utility service, but may not be able to pay the full amount asked for. So there are a couple different options. I'm not going to go down the slide in order, but the first thing I wanted to note is that there's a winter moratorium in Pennsylvania on terminations of gas and electric service. It's starting December 1st through the end of March 31st. Excuse me. Regulated utilities cannot terminate households with income below 150% of federal poverty. And so low-income households are protected from termination during the winter if their service is on December 1st. It doesn't guarantee a restoration of service if their service has been turned off before December 1st. And you will see then a high volume usually of terminations starting in April and May as utilities catch up to people who they weren't allowed to terminate during the winter months. One of the first things to think about when when someone gets a termination notice is whether they're eligible for any of the assistance programs that Liz had been discussing. If you can get a gap in whatever the customer assistance program is for that electric or gas utility, they may that can often or the enrollment will prevent the termination. You can also, if that's the road that you're going down, you can reach out to the utility and see if they'll stay termination while your client actually applies. But the request of the application itself may not stay the termination, but the actual enrollment should if they're eligible. You can also look into hardship funds availability if there's if they're able to address the balance through a hardship fund grant or through a LIHEAP grant. There are also payment arrangements. So a utility ratepayer can enter into, if they owe a back balance, they can enter into a payment arrangement either with the utility or through the PUC that allows them to pay off that balance over time. And I'll get into that a little bit in more detail on the next slide. Another option, which I'll also get into a little bit more detail on, is medical certificates. If a individual in the household has a serious illness or a medical condition that requires the continuation of service, they can get a certificate from their doctor to temporarily keep service on and prevent termination for 30 days. And there are some specific rules around that we'll go into. Another thing to pay attention to is the utility can't require payment on arrears that are over 4 years old to form the basis for termination. So if there are arrears from a long time ago, it may be worth looking into whether the utility is basing the termination on those arrears and can properly do so. In addition, for victims of domestic violence who have a protection from abuse order or some other court order, they can't be charged for debt accrued in someone else's name. This is an exception to the general rule. If you live in a house, you're on the lease, and the bill is in the name of your roommate, you can still be held liable for the amounts that are accrued while you were living in that house. Only if you are a victim of domestic violence with a protection from abuse order or other court order can you get out of paying that amount. Victims of domestic violence are also eligible for additional and longer payment arrangements. And as I discussed earlier, additional notice of termination. So those are many of the options that exist for clients who are facing termination. So I'm going to talk a little bit more in detail about payment arrangements. Payment arrangements are, that is where a client enters into an agreement with the utility saying that they agree that they are liable for the amount due and that they would like to pay it off over time. So it's important to note that if a client is challenging the amount due in any way, they think they were overbilled or the meter was off or anything like that, they should not enter into a payment agreement on that balance because in doing so they admit liability for that balance. We also don't recommend that individuals enter into a payment arrangement they can't afford to pay. The utilities have all sorts of formulas in offering payment arrangements, and a client may be desperate and want to prevent termination, but they only have so many bites at the apple in terms of utility policies and PUC standards to get a payment arrangement, and if they've defaulted, that's a mark against them in the future. Utilities.
Jolene, if I could, I just want to add just one piece there that I think is really important to pay attention to, and that's in PPL service territory, they've automated the payment arrangement offers. So when they call in and say, I need a payment arrangement, it goes through a computer and they spit out a payment arrangement, which is often very unaffordable. The other utilities are moving in this direction. I would recommend that if you're working with someone, have them push through to be able to talk to a customer service representative and tell them that they're low income, and they should be able to offer a better payment arrangement from the start. Otherwise, that payment arrangement, as Jolene just said, will count against their kind of count of how many payment arrangements they can get.
Yeah. Thanks, Liz. I think that's a really important point. You know, and you know, I think we often push back against utilities to say, you know, they do have legally the discretion to offer as many payment arrangements as they want for any length of time. There are no standards that apply to what the utility, in terms of external legal standards, to what the utility can offer. They have their own internal policies and will often say they are bound by specific policies, but those are policies that are internal to the utility and not external from the regulator. So it's always, if you have a particularly compelling case, always worth pushing the utility a little bit to see if there's something they can come up with. So the Public Utility Commission can also issue payment arrangements that require the utility to enter into a payment arrangement with a customer. There are two kinds, one for current customers and one for someone who's trying to get connected to service. For current customers, if they are low income, under 150% federal poverty, essentially there's a formula. Public Utility Commission says, okay, you owe X amount. You have a 5-year payback time frame, 60 months. We'll divide the amount you owe by 60 months, and there's your payment arrangement. They don't take into account individual circumstances or ability to pay in calculating that amount. And they can't, you only get one PUC-issued payment arrangement. They cannot require a utility to enter into a second payment arrangement unless there are extraordinary circumstances. And then PUC can also issue a payment arrangement for applicants for service, people trying to get service turned back on after they've been without service for more than 30 days, and that's going to be a 24-month time period. So it's a much shorter time frame than the 5-year time period. There are some exceptions to payment arrangements, to these rules that we just sort of discussed. The first is that for victims of domestic violence, there are some exceptions. They actually are eligible from the PUC and from the utility for a payment arrangement that is over a reasonable period of time, taking into account a variety of factors: the size of the balance, the ability to pay, payment history, and the length of time over which the bill accumulated. This is something that often advocates have to push for. It is not something that is routinely offered even to people utilities know have PFAs or other orders, but it is something that they are entitled to. In addition, if a customer has been enrolled in CAP and they've missed payments and accrued arrears within the program, they are not eligible to get a payment arrangement from the PUC on those arrears. And however, generally the applicant or customer only have to pay whatever payments they missed on the CAP program to be reinstated. And so it's not their bank balance that they'll need to pay. If any arrears were frozen upon entering the program, it is just what the payments they missed. But the PUC will, if a customer calls the PUC will say, oh, these are arrears that you accrued while you were on cap. There's nothing that we can do. And if what the customer wants is a payment arrangement on those arrears, that is true. Reinstatement in cap should refreeze non-cap debt and continue to allow forgiveness over time. So those are payment arrangements. I'm just going to touch briefly on medical certificates. Households can obtain medical certificates to stop termination. If their doctor, it is within the doctor's discretion whether the doctor wants to submit a medical certificate to the utility on the patient's behalf. But the standard the doctor has to certify to is whether there is someone in the household who has a serious illness or someone in the household who has a medical condition which requires utility service to treat that condition. So something like asthma, which might require air conditioning, or if you use a nebulizer, that would be something that could, a doctor might say this, you have a condition that requires utility service. Diabetes requiring refrigeration for medication, that requires electric service. It's within the judgment of the medical professional whether specific conditions apply. It is not up to the utility to. The utility can't have specific standards around that. It's the judgment of the medical professional. What do you get with a medical certificate? Medical certificate stops termination for 30 days. No matter how long the condition is expected to last for, it will only stop termination for 30 days. A customer can keep submitting new certificates every 30 days if that customer pays all current charges on time. So if a customer gets a medical certificate at the beginning of June, if they pay their charges, whatever they use in the month of June, by the end of the 30 days, they are eligible for continuing medical certificates. And there's no limit if they continue to pay those current charges. So that's not whatever they owed before, but what they're currently accruing. They can get an unlimited number of medical certificates. If they don't pay their current charges, they're limited to 2 renewals of those medical certificates for 90 days of protection total on that balance. That is kind of the very basics of medical certificates. They're a good option to help individuals stall termination or stay termination while they figure out how to get the money together that they need to pay or enroll in CAP or have any sort of to get get a little more time to figure out what's happening next. In terms of reconnecting service, very briefly. Once again, the 4-year rule means that if you have arrears that are more than 4 years old, say you stopped electric service in 2013 and haven't been living somewhere where you needed to pay for electric service, if you go to your electric service provider, they can't make you pay those arrears from 2013 to restart service. In addition, if you are eligible for CAP, the Customer Assistance Program, the utility has to waive your any security deposit they might impose. So, and what they may do is require proof of income to show that you're under 150% of federal poverty, but you don't have to actually enroll in the Customer Assistance Program to get that security deposit waiver. Again, you can get the utility can offer you a payment arrangement, and again, the PUC can issue a payment arrangement if you're under 150%, over the amount due can be placed over 24 months, 150 to 300%, 12 months. And again, for victims of domestic violence with PFA or other court order, they cannot be charged for arrears in someone else's name, even if they were living at the residence when those arrears were accrued. And they are also, again, entitled to flexible payment arrangement standards. So that's a really quick overview of some options to prevent termination or to connect or reconnect to service. I'm going to turn it over to Matt now, who's going to talk a little bit about tenant protections for utility customers.
Hi, good afternoon, everyone. As was previously stated, I'm Matt Rich with MidPenn Legal Services out of our Harrisburg office. And again, I work primarily in the area of landlord-tenant, but just as kind of a natural flow from that, I run into issues with tenants that will experience problems with utility services as well. So to a certain extent, over the 12 or so years that I've been working with MidPenn, I've run into a lot of utility issues, and every time I do one of these sessions, I tend to learn something new, but for the most part, have dealt with a number of the issues that we're running into. So have some experience in dealing with these problems, and can kind of discuss with you folks, and hope to discuss with you folks here what to expect as you're helping tenants that are dealing with these sorts of problems. So we're going to talk first about a couple of issues that tenants may very well encounter as they're renting any particular property. The first one I want to touch on is the scenario where the landlord is responsible for any given utility payment per the terms of the lease agreement. And that landlord then shirks his or her obligations and doesn't pay the bill. What protections the tenant has. Now, the disclaimer that I'll put out there to start is that it used to be, back when I first started, that you could find properties where either all utilities were covered by the landlord, or usually at like a minimum we would see that the landlord would at least cover the water, sewer, and trash bills. We've seen, I think, a pretty drastic shift in my time there in working in this area, that we're getting to the point now with the rising utility costs across the board, both with electric, gases, but then also I think the next burgeoning issue is going to be with water and sewer. We're now starting to run into scenarios where I'll be advising my clients and tenants that if they find any place that has any utilities included, that's probably something that they want to jump on, because they're becoming very few and far between these days. But if we do run into a scenario, and I'd say if there is anything that's covered anymore, it's usually going to be the water and sewer bills and the trash bills. So I'm just going to use those as my examples, because very rarely do we see anymore that a landlord would pay for electric, or would pay for gas or oil perhaps. So I'll just kind of use the water, sewer as an example. But what a tenant has as far as protections are concerned are going to apply both to the PUC regulated utilities as well as the unregulated utilities. The overall concept of the protections is the same. There are a few minor differences between the two acts that apply, but for the most part, the concepts are the same. So you see there on the slide that if you're dealing with a PUC regulated utility, the act that we're dealing with is called the Discontinuance of Service to Leased Premises. And there's the site to it if ever you want to dive into that. And again, that's for a scenario where the landlord's responsible under the terms of the lease or the rental agreement. And then for unregulated utilities, which this is, as Liz said, and I second that, the wild, wild west of utility law. These are your municipalities. Those are going to be the folks that usually the municipalities you might run into the water and sewer and the trash. You may also run into scenarios where there might be electric generation as well. in those circumstances, it's the Utility Services Tenants' Rights Act, or USTRA as we call it. And again, those are scenarios where the service is in the landlord's name. The concepts that are going to apply for tenant protections in either event, whether it's a regulated utility or unregulated utility, is that first, the tenant has a right to be notified of the arrearages that the property owner owes in advance of the termination of service. Now, that's the legality of it. The practicality of it is that could end up being an issue for a tenant for a couple of different reasons. One reason could be just as simple as the landlord doesn't keep up with their end of the bargain and doesn't notify the utility provider that the property is tenant occupied as opposed to being a property where the owner, him or herself, would occupy. So it may be that the utility provider doesn't know that there are tenants occupying a property as opposed to the owner. There would still be notices sent to the property, but they wouldn't be the same type of notice as would be required if the utility provider is made aware that it is indeed tenant occupied. Now, another scenario where it may become a problem is even if the landlord does indeed notify the utility provider that the property is tenant occupied, is if you have a multiple dwelling unit, right? So we might run into a scenario where say there's a row home and it's occupied on the first floor by one tenant and the second floor by another tenant. The tenant on the first floor, if the utility provider comes out and say posts a notice to the property, that tenant on the first floor is likely to find that notice, but they may very well not either communicate that with the tenant on the second floor, the tenant on the second floor might not see that, or they might not get their own notice. So there are circumstances where an individual may have service terminated and notice may have been posted to the property, but that individual might not be aware. So we have run into that on some occasions, so something to be leery of. Now, assuming, again, let's just use kind of a hypothetical ideal scenario. You're the only tenant living in this property. Your landlord's done the right thing and notified the utility provider that it's tenant occupied. You do get notice that your landlord's not paying the bill. We'll run into this a lot in mortgage foreclosure scenarios where the landlords have basically just kind of jumped ship. They know that, they're not going to be able to retain the property, and so up to a certain point, they'll try to get rent out of the tenants, but at some point they may ultimately just essentially disappear for all intents and purposes. And so say that the tenant, they get this notice. Usually the tenant's going to try and communicate with the landlord. There'll be some instances where the landlord will be able and willing to fix the problem. It might have just been a simple oversight on their part, but I think in a lot of instances you end up running into scenarios where the landlord, for one reason or another, just isn't able to afford the bill. So in that scenario, a tenant in either a regulated or unregulated utility situation is going to have the opportunity to avoid that threatened termination by essentially assuming the bill. Now, the important distinction is that the tenant's only required to pay the last 30 days of usage. The tenant's not required to pay the full outstanding balance. So if the landlord hadn't paid for the last 6 months and the balance is $1,000, the tenant only has to communicate with the utility provider. Usually what the utility providers will require from the tenant is a copy of their lease and a copy of some form of ID just to verify that they are who they say they are, in order for them to then be able to utilize their rights under either discontinuance to lease premises or USTRA. They reach out, they find out from the utility provider what the past 30 days usage is. If they themselves, the tenant, remits that payment to the utility provider, that will allow the tenant to effectively cease the termination of service. Now, what happens then is that the tenant, in a lot of instances, and again, there's some variations between, say gas, electric, water, sewer. They may or may not be able to have the account transferred over to them and pick up with bills. At the very least, even if they're not able to have the account transferred over, the utility provider should be able and willing to provide them with copies of ongoing bills, and the tenant then has the ability to assume the payment of the ongoing bills to allow for service to remain intact. In that scenario, what the tenant can then do is, because they're now assuming that this was a situation where, especially if it's spelled out in the lease agreement, that the landlord was supposed to be responsible for that in the first place, the tenant can then deduct any payments that are made to the utility provider from their ongoing rent. And there are protections under both of these laws here that we've discussed that will prevent the landlord from retaliating against a tenant who exercises his or her rights under these acts. So what you may end up seeing is a scenario where I can't fathom why a landlord would do it, but crazy things happen with landlords, especially. If the tenant pays a $100 bill to avoid a termination of service, and then sends their rent in the next month minus $100 with evidence that they paid the utility provider, and the landlord gives them a hard time for having not sent in their full amount of rent, the landlord may, for some reason, feel justified in filing a complaint at the local magisterial district judge, trying to evict that tenant for a non-payment of rent. And that would be a scenario where the retaliation provisions would protect that tenant from having to face any type of legal action from the landlord in that regard. Obviously, if you're going to be working with tenants, the biggest thing is to try to advise folks to try to keep documentation and records of any such transactions in case this does become an issue, and then in which case it should be as easy as just simply going to a judge or whomever and just showing them the paperwork to document the transactions, and that'll get it squared away. Now, the other situation that a tenant might encounter is what we call foreign load, okay? And what that is, that's a situation where, and this is, I can give my own, I usually use my own personal example. I rented a property once where my wife and I rented the front half of the property. There were tenants on the back half of the property, and then we shared a common room for a laundry room. And so what is supposed to happen in the majority of cases, not always the case, but in the majority of cases, ideally what you'd run into in my hypothetical, there would be a meter for my apartment in the front half of the house. There'd be a separate meter, a second meter for the back half of the house, and then there would be a third meter for the common area laundry room. And then let's just use the electric example. If we're talking about PPL, which is our service area that we deal with, I would have a PPL bill in my name to cover my usage on my meter for my apartment, the same with the tenants in the back half, and then the landlord would have the meter for the common area. Now, what we run into with foreign load is a scenario where it could be either just that the building was, the wiring is very old, or you could be running into scenarios where it's a nefarious landlord that for one reason or another might be trying to have a different tenant pirate electric, or it could be the tenant him or herself. They know what they're doing with their electric. They could go and try and hook into somebody else's meter. So, in my hypothetical, if the landlord didn't want to cover the electric bill for the common area laundry room, if that landlord then sent an electrician and had them wire it to my apartment, if I see a spike in my bill, or if I move in and I think my bill's way too high, I can contact the utility provider, have them come out and perform a foreign load investigation. And if they do indeed find that there is a foreign load wiring issue, whether it is purposeful or not, what happens in those scenarios is that whatever the balance is that's owed on the account at that point in time is then transferred out of the tenant's responsibility, name and responsibility, and transferred over to the property owner. The property owner then is required to make the necessary repairs to fix the problem and make sure that that foreign load no longer exists. And once the utility provider can confirm that the landlord has indeed made the necessary repairs, only then will they transfer the account back over to the tenant. Now, I think that there's, at least potentially some sort of disputes that might be raised in this area, but my understanding of it, and as is outlined here on the slides, is that in that scenario, number one, the tenant's going to be protected under the same retaliatory eviction provisions as we discussed with USTRA and the like, but also that once that bill's transferred back over to the tenant only pays the ongoing usage and payments. Any of that back balance that was accrued during the period when the foreign load was present becomes the responsibility of the property owner and stays their responsibility. And this is going to apply to all regulated water, electric, and natural gas utilities. This does not apply in the unregulated context. Now, moving on, last thing we want to hit on quickly is just the dispute process for the Public Utility Commission. Obviously, again, we're dealing with the regulated utilities, not the unregulated. So if you're dealing with your municipalities, this is not going to be an option. But if you're dealing with the regulated utility, you are going to be able to exercise a dispute process through the Utility Commission. So the first thing that's important to understand with the process is that it does have a requirement to it that you first start with negotiating with the utility provider. So utilities have pretty significant discretion to be able to determine, how they're going to work with one individual or another. I can just, I think you ultimately just, the biggest thing I would say, and to be quite frank, in all of the years that I've been working with individuals in utility disputes, I would say 99% of what I've done to help individuals is non-legal in nature. It's really just a matter of knowing who is the point of contact in the customer outreach department, which every regulated utility provider is required to have staff members that are designated as customer outreach individuals or something with a similar name. And those are folks that, if you're going to be assisting individuals with the utility issues, you want to get to know those folks because, frankly, for me, it's always just a phone call to the right person saying, hey, what's going on with this account? What are our options here? And, again, over the course of time, in almost all of the cases I've ever dealt with, it's been a simple phone call to get it resolved in one form or another. Now, there may be a rare scenario where the utility provider just says, based on the payment history or what have you, that there's just absolutely nothing that they can do to provide any further assistance. And if that's the case, if you've tried what you can with the utility provider, then it's on to the PUC to see if you can have the PUC intervene and assist. So we have the process there is outlined in the code. The two important things to note is that it starts with an informal complaint. And when they say informal, it's meant to be pretty informal. It's as far as I understand it, it's calling, and I think they have you fill out a form, Liz. I'm sorry. Is there a particular complaint form, I think?
No, I mean,
okay.
If you do it you can submit a complaint online, in which case you have to fill out the online form, but otherwise you can just call that 800 number and talk with the...
Yeah, and you lodge your complaint. The important thing to note there, which we have noted there, is that filing an informal complaint with the PUC will at least temporarily stop termination so long as it's filed the day before the termination is scheduled. So if you've got a Thursday termination, you want to get a call into the PUC on Wednesday, and if you do that, it will at least temporarily stop it. Again, it's a pretty informal process. It's mostly just you call the PUC and they listen to you and you lodge your complaint, and then the PUC is likely to then turn to the utility provider and get information from them, and then the PUC issues a determination. There's not a whole lot of digging done. I mean, when we say investigation, it's mostly just seemingly one conversation with either party and then issuing a determination. There is paperwork to this. There's a letter that's sent out to let the customer know what the result is of the informal complaint. If it is indeed resolved through the informal complaint process, then obviously we're good there. If the informal complaint process, if ultimately the PUC responds with a letter saying that they investigated and found that the utility provider did nothing wrong and there's nothing more that they can do, they will give the customer an opportunity to essentially appeal that decision and file a formal complaint. Now, in the formal complaint process, this is where we are going to ultimately lead to an administrative hearing before an administrative law judge, and then any appeals from those decisions are going to go to Commonwealth Court. An important note that we have on there is that any time there's going to be any interactions with the PUC, any individual who is representing, say, a customer's interest does need to be an attorney through those processes, but advocates and paralegals, and I know we have like local social workers that are very in tune with how the process works, and at the very least you can provide the contact information and provide some, and I think if you go on the PUC website, there may even be like a web page where you might be able to print out and just give informational materials to a customer, even if you're not an attorney, just to get them aware of that process and to get them started in that process. So I think that covers what I was going to hit on as far as tenant issues and tenant protections. I'm going to let Liz and Joline maybe chime in on referrals for their part, but I'll just talk about MidPenn very quickly. If you're in our service area, which if you go to the Pennsylvania Legal Aid Network, where they have we have a link there, there's a map which makes it very easy to kind of understand. There's a legal services or legal aid office that is going to, they may not have a physical office, but there's at least going to be an office that covers every single county in Pennsylvania. So no matter where you are as you're listening to this, there's going to be a legal aid provider that covers your county or your service area. It's just a matter of identifying which one, because there are different outfits throughout the state that operate in different areas. So like MidPenn Legal Services, we operate in the middle 18 counties in the state. We're kind of aptly named that way as MidPenn Legal Services. If you go check out the map, you'd be able to see all of the different counties of our service area. If you are going to make a referral, we have a bit of a unique system, and in that if you're dealing with Lancaster or York counties, you contact their offices directly. Any other county, like in my instance with Dauphin County or Perry County, they all go through what we call a coordinated intake unit or a centralized intake unit, and you'll see that 800 number there. That's anybody that's seeking assistance in our coverage area would contact that 800 number. They'd be screened for assistance, and then depending on the circumstances, if it is something with which we assist, they actually get transferred right as they're on the phone and they're screened and found eligible. They get transferred right to an attorney to discuss the situation, or depending on the circumstance, they might just get an automatic referral to whichever office it is that would be dealing with their problem.
So I'll jump in real quickly, and I want to make sure that we get to there's a question in here, but I want to note that PULP does run a utility hotline. It is for emergency cases where folks are facing immediate loss of service or are already off. The 88844 number is up there. I'll note that we're a very small staff of 4, make sure, if you can, make sure that you're sending an appropriate case our way, so that we don't get overwhelmed and have to shut it down. But for now, that's a resource that's available for referrals. As well as if you are assisting someone, you can reach out to us at the PULP line, or you can call me directly if you just want a little advice on how to handle a case or how to assist a client that you're working with. And I'll turn it over to Joline to talk about CLS, but real quick, if I can, there's a question from Lisbeth asking, is there a mechanism to clearly alert housemates when they sign a lease that they could be held responsible for utility bills in their housemate's name? That is a really good question, and to my knowledge, there's no mechanism, though it would be a great thing for us to think about standard lease addendums that might alert customers. Unfortunately, there's no legal requirement right now that they be alerted to that. It was a change in the law about, I guess, 15 years ago now, to try and stop the name game, which is a shorthand for folks calling in and getting service turned on in the next person's name and the next person's name. There's lots of reasons for that and reasons against that, but unfortunately it's the law and we're stuck with it. Sadly, Lisbeth, you're absolutely right. People get caught all the time with their housemates' names, bills in their name, and it's unfortunate. But right now, there's no mechanism alerting folks to that. So it's up to us as advocates to be informing tenants as much as we can. And then the second question is, why are regulated utilities not required to list the PUC Bureau of Consumer Services number on the bills. Another good question, I do not know why they are not required to, but they are required to list it on the termination notice. And the last question, what recourse do electric utilities have when they've been preyed on by alternative energy suppliers? You can read the rest in there that there's some pretty severe cases, and I'll note that we've seen some pretty severe cases. And unfortunately, our legislature decided to deregulate the electric supply side. So we do have, some unfortunate problems cropping up. I would say still have them if they're experiencing a supplier issue. They should still call the PUC Bureau of Consumer Services and launch a complaint. There's been a number of large class action lawsuits against bad actors in the market to several million-dollar settlements. So, the more that the abuses are reported, the more they'll be heard.
And if I could just put one note on, especially for folks who are going to be dealing with tenants as advocates, I don't think I'm overreaching to say that, not that you would advise someone to not shop necessarily, but certainly if you don't advise them to just not shop altogether, certainly they have to be very, very careful with that whole setup of shopping for electric. Without getting too far into the weeds, there's a lot of potential pitfalls with the way that those service providers set up their billing practices, and folks think they're getting a deal, and they very well may, but they have to really read all the fine print, and it can be very, very treacherous. And so if you're not cautioning folks against shopping at all, definitely be cautioning them that if they are going to shop, that they really should be running it by you or anyone else that they can that can help them really dig down into all of the details of any given bill or any given contract that they're going to get involved with.
Yeah, and so the utility is still required by law to provide electric service at the least cost over time. So while at any given moment it's not going to be less, over time it's always going to be less. So, while you may not want to advise folks not to shop entirely, I think you're absolutely right, Matt, that the advice should be high caution, and unless you want to monitor your bill every month, you've got to stay away from them. There's another question that popped up. What's the difference between the PUC and the Office of Consumer Advocate? That's a good question. The PUC is the administrative agency that they're basically the courts of utilities. The Consumer Advocate is an office within the Office of Attorney General's office. That's a lot of offices. But they are charged with protecting the interests of all residential ratepayers. So they are, on the consumer side, and so if you're dealing with someone who's not low income and they're having issues with their utility, the Office of Consumer Advocate is a great resource to send them to. So they wouldn't be launching a complaint there; they'd be getting some advice or some assistance with advocacy. Joline, you're not in the same room as us, so I want to give you a shot to explain what CLS does, and I know we're over time, so if folks need to jump off, that's fine too.
Yeah, thanks, Liz. CLS, we focus on the City of Philadelphia, so if you are in the City of Philadelphia and you have clients who are having trouble with their PICO, PGW, or water bills, you're welcome to send them our way. We have intake both at our Center City office and our North Philly office, and they will have to come in for in-person intake, but the numbers that are listed on the slide, they can call, individuals can call and see when our hours are. Anyone is also welcome to get in touch with me, and I'm happy to provide assistance on specific issues to PICO, PGW, and the Water Department.
Very good. Well, this is Val at the Housing Alliance, and just thank you all for presenting. It was very informative, and I'm sure very useful information for many of the folks on the call. I do want to repeat that we will be sending out next week the PowerPoint presentation to everyone that's registered for the call, and we will be uploading it on our website as well. So I know we're over a few minutes. I'm happy to keep the line open if if the speakers want to address any more questions people have. But otherwise, I want to thank you so much, and I wish everyone a great weekend.
Thank you.
Thanks for joining us on your lunch break, everybody.
Thank you.
Okay, great. Thank you, everyone. Take care. Bye-bye.
All right, good one. We made it.